and welcome to another edition of the Education Magazine podcast. And today, Chris, we are going to be talking about social care. Chris, good afternoon. How are you?
Good afternoon, Mike. Nice to be back.
Good. And with us today, we're going to be talking, as I say, about social care needs. And that's a very topical subject because, of course, I've been talking before about inappropriate assessments generally in regard to education cases, Chris, haven't I? And we're honoured to have some very special guests with us today. We have Professor Luke Clements, who is a Professor of Law at the University of Leeds and was also an advisor to the Parliament on the Care Act. So hello, Professor Clements. Thank you for joining us today.
Lovely to join you. Thank you.
And also a warm welcome to Kathleen Long, and you've met her before because she's been on our previous podcast. She's talked a lot about FII cases, didn't she?
She has,
and,
yes.
She's with us today, and she'll be talking about the Chronically Sick and Disabled Persons Act. Kathleen, nice to see you.
Thank you. It's great to be here. Thank you.
And Cathie, you're a independent social worker, expert in autism, and having got an MA in regard to autism, and a regular expert witness in the courts, aren't you?
Yes, I am. So, yes.
And this is an area that's been concerning you for some time, isn't it? Social care and the approaches to those with disabilities.
Yeah, it's something that, I'm primarily assessing disabled children and young people. And one of my real interests has always been the law in terms of social work practice. And, I'm sort of always very surprised that a lot of social workers don't know the law and don't know how to apply that to the people they're assessing. And so I think sure Luke will support this, but, a lot of people with disabilities aren't getting the best services or the services to meet their needs. And a lot of parents don't know what they're entitled to. And that's why I believe it's really, really important to be having this conversation today.
So you're all with us today to hear about the law. Chris, let's talk about the law. And we start with, I think, Section 17 of the Children Act, don't we, I think?
Well, I think that's always a good starting point. And also we're going to be talking about the Chronically Sick and Disabled Persons Act as well, 1970. So a lot of law in this episode, but luckily we have our two experts with us to hopefully unpack it and make it a little palatable, because I don't think everyone is as much of a nerd as we are, Mike.
No, absolutely not. Well, we'll start, though, with the general duty. And the general duty under the Children Act is to safeguard and promote the welfare of children who are in their area and who might be in need. And need is defined in the Act in a specific way. So, Professor Clement, could you tell us how need is defined in the Act and the distinction between need that is defined by most local authorities up and down the country?
Yeah, if I could just take a step back. First of all, to define a disabled child, basically. And then if the disabled child has needs, then the legislation says those needs can be met in a variety of ways. So the Act defines a disabled child. The Children Act defines a disabled child in Section 1711 in a very broad way. It's really a child that's got a sensory impairment, for example, blind, deaf, or dumb, but also has a mental disorder of any kind. And it then goes on to say, or has a substantial and permanent handicap, which is not language we'd use, but it's in the Act. So that's what the courts will look at. I think the really interesting phrase is a mental disorder of any kind, because that's really what it says on the tin. It's anything that comes within the definition of a mental disorder. And that doesn't have to be permanent or substantial. And a mental disorder really is the definition used in Section 1 of the Mental Health Act, which says any disorder of the mind. So high-functioning autism, attention deficit hyperactive disorders, as well as the sort of more traditional learning disabilities or mental health problems come within that definition. So Parliament, when it enacted the Chronically Sick and Disabled Persons Act in 1970, decided that the people that came within that definition should be assessed as to whether they have needs for a whole range of services. So those could be practical assistance within the home, there could be adaptations to the home, there could be activities in the community, there could be travel to community activities. And those rights still are exactly the same today for disabled children. Very broad, and they're what's we call specific duties. Once a local authority has decided you've got that need, it's got to meet that need regardless of its resources. So these are very these are rights with sharp teeth, and local authorities can't pick and choose who they assess for these rights. So they can't say, well, in our area, you've got to have not just a mental disorder, but you've got to have challenging behaviour and you've got to have a diagnosis or whatever, because the Act doesn't do that. You can't lay additional boundaries on something that Parliament has decreed everybody in England has the right to. But local authorities do that, and we'll probably get on to that in a minute. But the Act says that once those needs have been identified, then they've got to be met. And then it is a curious relationship between the Chronically Sick and Disabled Persons Act and the Children Act, which really most people don't need to know about. I suppose the useful thing that is to be know about is the Children Act says that if you have a need, including a need under the Chronically Sick and Disabled Persons Act, you, the parent, have a right to have that as a direct payment rather than to have, the taxi service to the social care or the local authority arranging the personal assistant. You can have a direct payment yourself. So very wide duties. Local authorities tend to have policies that say, well, you can't access these rights unless you've got quite significant impairments, and for instance, you're seen by somebody from the disabled children's team. But in my humble opinion, those are unlawful policies, but it's quite difficult and often the social workers don't know that they're operating unlawful policies, but it's quite difficult for parents to sort of bash the door down and get a proper assessment.
And that's the starting point, isn't it? Because you can get an assessment if your health is likely to be affected by an absence of services, not just simply whether or not you have a disability, but we're talking here about those with a disability, yes, who are entitled to specific services. Interesting, Chris, because there's a case that we are involved in at the moment, and we're going to be hopefully taking to the court if it goes that far, over this point about, and the interesting thing I'd like to ask Cathie this. Cathie, what's the distinction, in your view, in a practical sense, between the children with disabilities team and the general social care teams that are often engaged when a social services assessment request is being made?
Okay, most often when I'm involved as an independent social worker, a child or young person is assessed by the children's services rather than the children's disability services. And I think Luke has some statistics about that a very small percentage of children with disabilities are assessed by the children with disabilities team. And I think there's a lot of, in social care, social workers are assessing a very, very broad spectrum of differences in disabilities. And I think there is a real distinct lack of training for social workers to have an in-depth understanding of some of the disabilities that they're having to assess people with. And so, I'm thinking, for example, I run advanced autism training courses for social workers. A lot of social workers have a sort of tip of the iceberg understanding about what it means to be autistic. And I think some would think, being autistic is like being the Rain Man, and it's not. We all know that. So, I think one of the things that also happens is children are assessed by child protection social workers and ends up, disabled children, and they're assessed under the same criteria. So it could be a social worker walking in saying, well, I need to see the child's bedroom, I need to see the bathroom. I've had one child who was very, very disabled where they were being sort of checked for bruising. And when it went to tribunal, the tribunal judge was absolutely sort of very, very forceful that this should never have happened. So, these are the differences. And I think also from a parent's perspective, the parents I work with, they end up feeling they have to jump through so many hoops just to get a good assessment and to get the right services. And I don't see that happening very often.
That's very interesting, Cathie. Professor Clements, we've just heard Cathie talk about the distinctions between social services. In your research in this field and the distinctions between these kind of internal teams, as it were, is there a difference in training? Are we seeing a difference in outcomes where people are assessed by different teams? Is that borne out in the data?
Yeah, the data doesn't necessarily. The research that we've done shows that there's actually very little training of all social workers concerning disability or human rights awareness. And I suppose the difference between a disabled children's team and a generic child assessment team is really in terms of experience. Only about 9% of assessments done by children's services are of disabled children's team, are of disabled children. The overwhelming majority of children assessed are children considered to be at risk of or suffering neglect or abuse. So, and that is really what the generic team is involved in. So if you're not lucky enough to go to a disabled children's team, which is only really looking at disabled children who are not necessarily suspected of neglect or abuse, then you're going to be being assessed by somebody who is working to a hymn sheet effectively of safeguarding. And as Cathie's just said, they will be wanting to see your bedroom or your child's bedroom. They want to speak to your child alone, and so on, all of which are very severe violations of your right to privacy and respect for your family life and your home and so on.
Yeah.
But being devil's advocate, just a moment. I mean, would the council, I know that the council, this is purely devil's advocate, by the way. But, I mean, the council will argue in response to a challenge like this that it has an obligation to consider not purely the needs of the disabled person, but their needs for health and development. And they might say, well, actually, the ambit is far wider than the distinct approach that you're asking us to look at. And they might also say, and I know they have said in response to a challenge I brought recently, there's no difference between these teams. You know, a generic social care team will be in tune with the support services that are available under the Chronically Sick and Disabled Persons Act. What do you say about that?
Well, I don't think any social workers, even in the disabled children's team, are attuned to the rights under the Chronically Sick and Disabled Persons Act, because social workers are not getting any legal training, according to our most recent research. Social workers will follow the guidelines laid down by their local authority. And their local authority policies will normally have a sort of a graded 1, 2, 3, 4 level eligibility criteria. Only the children at level 4 will be eligible to a range of services that are of the type described under the Chronically Sick and Disabled Persons Act. And only children in level 4 will be seen by the disabled children's team. So the vast majority of disabled children will not only be assessed by generic social workers, not ones with experience of disability, but they won't be able to unlock the door to Chronically Sick and Disabled Persons Act services because they're seeing the person and they're not, therefore, at level 4. And level 4 is what the local authority says you've got to be before you get all of these services. So it's just not true if a local authority says, basically, these are separate but equal. All children are assessed and all children can get these services, because there are umpteen ombudsman's cases, and our research shows umpteen eligibility criteria that says these services that Parliament intended to be reserved for all disabled children are actually only accessible for a very small number. I mean, we've about to publish some research that says that only about 2.5% of all disabled children are seen by the disabled children's teams in England. So 97.5% of children are not able to access the rights that Parliament intended them to have a chance of getting 50 years ago.
Goodness, it bears for quite frightening news, I think, to see how few children are accessing, the rights that are intended for them. And as you say, and as we've discussed, it's one of the key things is that it's all well and good to assert, as you say, that they're separate but equal services, but where we're not seeing the same outcomes, where we're seeing much worse assessments for children and young people with disabilities, it really, doesn't bear out, does it? So quite frightening. But Cathie, when we're talking about assessments, so we've talked a lot about, I suppose, poor assessments and assessments that may be done by those perhaps not properly trained to actually look for the type of needs that we're looking for under these acts, the Children Act and the Chronically Sick and Disabled Persons Act. So what does good assessments look like? What should you be looking for as a social worker when you go to do one of these assessments of a child in your area?
A good assessment should be child focused. So engaging with the child, looking at what they need, sort of seeing the world through the child's eyes, whilst not negating the importance of the family around them. So the importance of their parents and siblings as well. So that's one part of it, and that's the emotional connection, the practical support, the difficulties, what's working well, what's not working well. And that's really important, because I know there's this misnomer that the needs of the child in the Children Act are paramount. They are. However, the child is not a separate entity in that family. And so too often parents are told, it's not about you, it's about your child. Well, actually, the two are integral. And there can be big knock-on effects. The other things are looking at, I like to work from the basis of going in, looking at what the needs are and applying how can we meet those needs within the existing framework of the law? What's there? So that's about a good assessment. What can we do? What creative solutions can we have here that are going to make this family work well and to prevent the risk of family breakdown? And so looking at what do they need? Because too often families, they're in crisis. They go to social care believing that we social workers are nice people, we're going to help them, and then end up having sort of not getting services, having to fight and getting more and more and more sort of at the end of their tether, not coping, and it becomes a very, very stressful experience. Social work should be about preventative services. It should be about putting support in at the point of need to stop a family from breaking. So that's the sort of key bits. But I love the Chronically Sick and Disabled Persons Act. And when I started off as a social worker in the 90s, I worked with older adults, and it was very much about care in the community. And these things are really, really relevant in this piece of law. And it can be things like practical assistance in the home. And that can be that could be, the old days used to have home helps, but might not be a home help now, but it could be personal assistant for the child or the family. But also thinking about home adaptations. So it can be a lot more cost effective to adapt a family's home with the Disabled Facilities Grant or equivalent than for a child to go to a very expensive school or residential place.
Cathie, can I just stop you? What about a child who is looking after a very sick relative, a very disabled relative?
Well, they've got rights as a young carer to have their needs assessed and to be supported to do that. And actually, I don't think a child should be in that, they're a child. My view is they shouldn't be in that situation on their own anyway. It's sort of a bit like, I understand it happens, but I also believe it's a social care responsibility to support that child so that they're not having to do anything above.
Well, that's my point. It's a demonstration of failure in action, isn't it, really? Yeah.
No, absolutely.
So, but also with the Chronically Sick and Disabled Persons Act, so there's some very old terminology because it was only sort of happened a few years after I was born. So, it can be about obtaining, it says a wireless television, library or similar recreational activities. Well, I don't think anyone wants a wireless anymore. However, it could be sort of transferred. This child really needs an iPad, or, you know.
Absolutely, yeah.
You know, those sorts of things. And lectures, games, outings, recreational activities, that they're part of the Chronically Sick and Disabled Persons Act. It can be adaptations, sort of like rails and things going up and down the stairs, those sorts of very practical things. It also, and this has happened with some of the people I've worked with, they've had a sensory room built for their autistic child or adult, where they've got a space that's safe that they can go into, which has meant that they can stay at home. And I think there's some research that was done, I can't remember which university, a few years ago about this. And I think, again, that might sound like a luxury, but if that prevents a family from breaking down and helps to alleviate incidents of behaviour, you know, behavioural presentations that are challenging to manage, etc., that's going to be a really good thing. And also it can be a space where the carer can go into, the parent, and just sort of get away from it sometimes. So it's having that creative approach to looking at the needs of the family.
Can I just jump in there, Cathie? Because it was we that did that research on adaptations and sensory rooms. And that showed that for every £1 that was spent on a disabled facilities grant, or disabled facilities work, the local authority saved at least £5 and probably £10 or £15. So it was working out at millions of pounds savings. The point about it's actually a very important point, is that if you want to adapt a home, you can get a disabled facilities grant, and if you're a child, it's non-means tested. So and it's 30,000 in England. Most disabled facilities grants for adults only cost about 7,000. They're stair lifts and things like that. But most disabled children's adaptations cost about, for a ground floor extension, about 70 or 100,000 pounds. So the disabled facilities grant only takes you 30,000 of the way. So you've got another 40,000 to raise. And that's where the Chronically Sick and Disabled Persons Act comes in, that the local authority will say, well, we'll give you 30,000, but you have to take on a new mortgage, or you'll have to make a contribution of 40,000. And the answer in those situations is no, you've got to first consider your duties under the Chronically Sick and Disabled Persons Act to pay that balance. You've got many families mortgaging themselves, getting into debt to pay the additional cost. But that's what the Chronically Sick and Disabled Persons Act there is for. It's to top up where things like the DFGs are not sufficient.
But there's a duty to do an assessment. I mean, what you're saying is really, it is a real cause for concern, because the gateway, if you like, to this whole range of services is met by a barrier that's erected by the council through the route that they choose the child go down. I mean, how can you challenge that legally, though? I mean, the duty to undertake an assessment is where what the Act talks about. How can you challenge the local authority's approach to say, well, look, when they respond to you by saying, look, we're doing an assessment, we are complying with our duty to Section 17. What provision do you say we are breaching by our doing a generic assessment?
Well, I mean, I don't think there's necessarily anything unlawful about doing a generic assessment, providing the assessors have the skills necessary to do that. They're competent. And one of the competencies is that they not only understand their legal responsibilities, but that their understanding is correct, effectively, in the sense that they're not operating to a local authority guideline that is contrary to the law. And quite astonishingly, and I'm sure you're more familiar with this than I, very many local authorities on the face of their website local offers are just saying unlawful things, that you can't access this unless that. So the first thing is, I'm not going to object to, I can't really say who assesses me, but if they don't have the skills and competencies to understand autism, say, or pathological demand avoidance, if it's obvious that they don't have the skills, then I can say that that's a flawed assessment, because an assessment, as you know, will look at all issues and will need to have an understanding of those issues. The challenge to the assessment is when the assessment says no, you're not eligible to this, because the local authority then has to give reasons as to why the presenting need, the need that the family is talking about, the need that they've documented in the assessment. The local authority has got to come up with a cogent reason for saying no, a rational reason. And sometimes they'll say, well, you can't have this because only this is available from the disabled children's team, which is clearly unlawful. Or sometimes they'll just say no because the budget's spent, which is completely unlawful because it's a non-resource dependent duty. So you then need to analyse the reasons for them saying no. And if the evidence is overwhelming, that absent significant support, the family or the child will suffer significant harm, emotional harm, physical harm, social harm, then the more clear it is that the consequences will be serious, the more difficult it is for the local authority to say no. But if they do persist in saying no, you only really have two choices. One is to make a complaint, which is often the process that you will go through, or two, to find a good firm of lawyers. I don't know if you've got any tips on that.
One of the other areas that parents will often seek support for is accommodation. And there are duties to accommodate under the Children's Act. And what we often find in practice is that a local authority will never really ask itself that question for the need for accommodation, primarily because they will say that as is the child's case, it's a matter for the education department to decide. But of course, a whole different rules apply when it comes to deciding where a child needs residential provision, because they will say, unless you can demonstrate that a child has a need for educational support that extends beyond merely the day, this is not a case for us. And then there's a conflict between social care and education. Cathie, do you see that a lot in your practice?
I do see that, and I think there is a very much a sort of sort of social care absolving their responsibilities for the child, and this is an educational decision. However, I would challenge that, and I've challenged that in tribunal many times, where it's like, I'm a social worker, I'm only supposed to look at social care. However, in the working together to safeguard children assessment framework, it covers education, it covers family relationships, parenting, recreation, all those sorts of things. And therefore, they are, I think it's, I could say irresponsible, but they need to be considered. I think a social worker needs to make those kinds of decisions as part of their assessment, but also in conjunction with the people, the educational psychologist or the school or other people, having that unbiased assessment and arriving at the right decision which meets the needs of the child. I think that's a really, really important thing. I don't know if I'm stepping out of what you've asked me, but I'm also thinking in terms of an education, health and care plan, EHCP in England, and the additional learning needs in Wales. But it's that under Section H1 of the EHCP so often, which is the Chronically Sick and Disabled Persons Act bit, is put no identified needs or not relevant or not applicable. And actually, it is applicable. It is not an archaic piece of law that doesn't apply to the sort of today. And they should be put, something should be put under that sort of heading.
Yeah, but it seems from Professor Clements' research, though, that there's the barrier to getting through that getting into the services that or the service available services under the Chronically Sick Persons Act is primarily created by the local authority through this route of saying, well, actually, you can't go to the children with disabilities team, you go to the generic team, and that opens the door. If you don't get it under the right team, you're not going to get the right service.
Well, it almost seems like a forgotten act, almost, doesn't it? It almost seems like, we're focused on the Children Act and assessments under the Children Act. Of course, the reality is that those assessments should encompass both acts. And they should have a wider ambit. And for those who are disabled, then obviously the Chronically Sick and Disabled Persons Act comes into effect, and decisions should be made under that act. But I think you're quite right, Cathie. I cannot recall. In fact, it's something that even I think, looking back, goodness gracious, how do we not see that? Because they're leaving, H1 blank and occasionally filling in H2. I mean, I think social care support specified within education healthcare plans is generally quite sparse. I think that we're seeing those improve now with the wider powers of the tribunal to make recommendations in respect of social care. But when we talk about the act as we have today, in terms of the Chronically Sick and Disabled Persons Act, it's quite clear that really for all those, or nearly all those who would get an education healthcare plan, I'm sure there's some exceptions somewhere I can't think of, but the overwhelming majority would clearly fall within, be it by virtue of a learning difficulty or a disability, and obviously disability automatically qualifying, within the ambit of the act. But we're just seeing that not applied at all. And it's quite clear from the way you described it, Cathie, that it's an act that is, as Professor Clements described it, with teeth. It's to have a practical function to help these children in a circumstance where they need real support. And yet we just see it often overlooked. And as you say, Mike, that is perhaps a systemic issue in terms of a lack of training and a lack of awareness about the law itself.
Well, you often see even the most complex cases where children are given education plans without anything mentioned at all about social care at all. Not known to social services, full stop. I mean, it never ceases to shock me, really. Yeah. But the entire thrust of on parts of local authorities to meeting children's needs is often, in my experience, ignoring even the most basic duties under social care legislation. And parents are often, I know, Professor Clements, you've been doing a lot of research on this, but parents are often frightened about even turning to social services at all, due to a fear that in so doing it will open up criticisms in regard to their parenting. I know the government have even mentioned that in its green paper on the SEN review points, and they actually specifically referred to an overwhelming majority of parents who were frightened to turn to social services because of this fear. And Professor Clements, please tell us about that and what your research has demonstrated.
Talking about today, in a way, disabled children are the sort of forgotten group of people in the Children Act, and so that when a child in need is being assessed, you've been asking this question: what is the assessment process? Well, there is no guidance on assessing disabled children. The only guidance that exists on assessments for children in need is safeguarding guidance. It's about abuse and neglect. So even if you're going to the disabled children's team, you will still be assessed using guidance designed for safeguarding for children suspected of neglect or abuse. The social worker will still come to your house, possibly without warning, because they're supposed to do unannounced visits. And they will say, do you mind if I look at the bedroom? Or I need to see the bedroom. And of course, parents are terrified of saying no, because, it's a non-question, because if they say no, that will go down on their notes. So they have to allow somebody to go into their most intimate spaces within their home. And then they'll say, do you mind if I talk to the child, who might have very serious sort of social issues about talking to strangers. And of course, then there's problems. And if you say no, it goes down on your notes. And many parents experience that as a really humiliating, undignified experience. And they just never want to see social services again because they are treated like criminals. Because the social worker is following a script, and it's the only script that exists, which is the script for assessing children who are suspected of neglect and abuse, because there is no guidance anymore. There used to be, but this was repealed in 2013, that was specifically aimed at disabled children for whom there is no risk of there's no suspected abuse or neglect. So you, and I'm sure Cathie and I and our research team, inundated by people who say we will never, ever go to social services again. We will never put our children at risk. And, have had worse experiences. And you've done, a program on fabricated and induced illness allegations, which are rife in this area. So, yes, there is a real fear of going to social services. So it's not surprising that H1 and H2 are blank, because people don't want to be known to social services. Social services who've got all these powers that Parliament have given them to help people overcome the impairments that they experience because of disabilities, the barriers, are actually seen as a force that will come in, look at your house, look at your fridge, talk to your children on their own, and fill out a form that's got tick notes about signs of abuse.
Yeah. It's something that we were talking about in the context of education on a previous episode, where we discussed how quality assessments really helps build trust between services, and that's something that can also reduce trust. And particularly, as you say, with the conduct and social care, as you say, it's a sensitive, intimate assessment in many ways, looking at the family's life, and is intended to look at the family's life, in a warts and all fashion. It's meant to look at the challenges, it's meant to look at the difficulties and help. But instead of helping, it can lead to people feeling exposed and feeling like they're being judged for these circumstances that, of course, are beyond their control. If a child has needs that makes things difficult for them or difficult for their family, that's what this support is there to help. And instead of having a supportive process, a supportive assessment, an assessment that makes people feel listened to, instead what it does is make them feel like they've experienced a harrowing, experience. They've been judged. They feel like they're not being helped. They're being just observed.
Yeah. And yet, ironically, children might be suffering significant harm due to the absence of the service that they were entitled to.
Not from their parents, but from the lack of services.
Of home adaptations and so on.
Absolutely. And
I think that's so true. I think as well that in some... one of my colleagues, Dr. Fiona Gullen-Scott, talked recently about, how children are so, their greatest thing when parents are accused of exaggerating or making up their difficulties, how the children are saying they have suffered. And, and yet social care is about, safeguarding children from harm. So they become the sort of person that creates that harm, not intentionally, but it is what happens.
The absence of looking to the service. I'm noticing here in the notes, the provision of lectures, games, outings, or other recreational facilities outside the person's home. So many children with disabilities don't have friends. So many children with disabilities are isolated in the home. They've got nowhere to turn and nowhere to go, and the parents are struggling, both financially and emotionally. And I can't imagine how many children left in that situation, Cathie, who are then talking about self-harm and wanting to die, as we often see, sadly, in these cases, directly as a result of them not having these kinds of services, the facilities for holidays, short-term breaks, all those things that we look forward to are being denied to children with disabilities purely and simply because the local authorities create very, very significant barriers and a fear among parents to gain access to these important services. Now, it's absolutely outrageous if you think about it. Is there not a case I'm thinking now aloud, is there not a case that we could think about doing that will challenge the government for not giving specific guidance to social care departments across the country when it's only given guidance to those who might be subjected to significant harm due to parenting, child protection issues? Is there not a case that that's somehow a violation of its general equality duties because it's denying proper set of criteria to be used for children with disabilities gaining access to this support? What do you think about that, Professor Clements?
Well, as you probably know, we did a major report on what we call institutionalizing parent blame, which we published last year. And we looked at the law and concluded, I think fairly strongly, that it is discrimination not to have specific guidance for disabled children, to treat all children the same. And as you will well know, that may not be something that falls within the Equality Act, but it certainly falls within Article 14 of the European Convention. There's a famous case that I'm sure you know very well called Clements in Greece in 2000, where the court said that treating individuals who are different the same is as bad as treating people the same differently. So treating people that have the same qualifications differently because of the color of their skin or their sex is discrimination. But treating people who are quite different, disabled children and children suspected of neglect or abuse, treating them the same is a violation of Article 14 in relation to your right to private and family life, Article 8. So there's what we will call Clements discrimination there, and it's clear. And so what we said in the report is that, we would call on the Secretary of State for Education to issue separate guidance, which this government, the coalition government repealed. And if it didn't do that, it would be very difficult to see how any reasonable Secretary of State could, not do that, i.e. that it would be a breach of Article 14 not to do that. And there's, as you know, quite a lot of case law on Article 14 discrimination. So there really is a strong case to make there. I know that there's been one challenge. So what you to do is you take a local authority that's doing this policy, but you then join the Secretary of State in those proceedings. And the argument would be no reasonable Secretary of State knowing about this problem that they've created by not issuing separate guidance could not fail to act. So you would then be seeking a mandatory order that the Secretary of State do that. In those cases, the local authorities normally, it is bad in a way. The local authority normally then cave in and say, we will do this. And the Department for Education says, well, it's premature because there's no victim now, because this problem's been solved. But there's a strong, there's an overwhelming case, I think, for proceedings to be taken, joining the Secretary of State under Article 14. And that's in the institutionalizing parent blame report. We talk it through in detail.
Well, that brings us nicely, I think, to the point about practical tips, Chris.
Yes.
I mean, because I can see a number of parents, I can imagine a number of parents watching this will say, okay, well, this is all very academic, very interesting. Yeah. What should I do in practice? So over to our team today. Please tell us, how are we going to approach social services from here on? What do you say to the mother or father who has a very disabled child at the moment at home, and they are frightened that social services might come in and criticise them, but they are in need and they are being met by a local authority that has told them that the generic team will be coming to see you because I'm afraid the criteria that we apply for access to the child and disability service, I'm afraid you've not satisfied. What's the practical tips do you give? Open to everyone to comment, but practical tips to a parent in those circumstances. What should they do? Professor Clements. Yeah.
I think the first thing is they need support, emotional support. I wrote a book recently on this issue of my sort of experiences, and I think that if you are somebody with those experiencing disadvantage, and it's a wide range, but you're obviously, if you've got a disabled child, you're experiencing disadvantage. You may not be poor, but you're having multiple problems. Is to get emotional support from a parent carer support group or somebody like that who can support you, because you're going to have an emotional buffeting, and it's that emotional support you need. You then need to know your rights, and I think just to download the institutionalizing parent care of blame report, which is easily gives you that, and I'd often, make sure that the local authority's seen a copy of it, because it often changes the way they behave. Because I don't think they're deliberately doing this; they're just following a script that isn't very pleasant. And I download some, I would, that parent care support group, I would download some support. Cerebra's got some very good specimen letters, template letters. If you just Cerebra, the charity, disabled children's charity, you can download some letters, template letters for England and Wales, which say this is what I want from an assessment, and just equip yourself. But I think it's incredibly important to surround yourself with some emotional support, because lots of parents talk about this as trauma. The system is giving them sort of post-traumatic stress because of the way that it deals with this. So they need to engage, but they need to have support. And if things go wrong, then they're going to need to have a bit more expert advice as well. And the advice that you're giving them is, it is obviously highly technical and accurate, but it's also empowering them in a way to see it through. To have people to say, well, this is awful, you shouldn't have been subjected to that. I think lawyers very often underestimate the emotional importance of what they're doing, as opposed to the technical stuff.
That's very, very true. I think that we've both experienced clients who just feel that reassurance, know that what they've experienced isn't correct. Just that sense of, oh no, I'm not being, absurd or crazy. That actually what I have experienced and what I felt was wrong was actually wrong. And that, as you say, that can be a huge salve to people who until now may have felt that they weren't heard. We'll make sure we put Professor Clements' resources that he mentioned in our description of the video and also on our website. But Cathie, I suppose when we talk about assessments practically, obviously that involves communication with social workers. Of course, as a social worker yourself, you're not a particularly scary person to talk to, I'd say, very pleasant indeed. But for many people, as we've talked about, it can be a very intimidating process. So as a practical tip to those who may be facing an assessment, maybe very nervous about it, how do you think it's best for them to interact with their social worker?
Well, I think if it takes cooperation. So I know I even say this to parents when they're sort of subject to child protection investigations. You have to work with the social worker. So I think that's important. It's important to be honest. But, and I say this with great sort of sadness, really, sometimes when parents have absolutely bared their souls, that's been used against them. For example, if a mother's experiencing depression and anxiety, that can be this child's difficulties are because the mother's depressed and anxious, rather than this mother can't cope because she's got a child who's not getting the right support, so it gets turned around. So I think that's one thing. Also, being really clear try the best about clear communication. So it's sort of say how the parent would prefer to be communicated with. It might be email, it might be, sort of letter, that sort of thing. Particularly for parents who might have their own sort of additional needs, like an autistic parent. I'm autistic, I get it. It's saying, this is how I prefer to communicate. I don't want sort of planned calls because I find that really difficult. Back everything up with an email. So if you're having a conversation, just sort of back it up. This is my understanding of what you've said, or you said that this report would be with me by Friday, that sort of thing. And that might be perceived as a bit of being a bit of a pain in the backside, but I think it's important to sort of establish those sorts of practical steps.
So Cathie, how do you actually identify that you're going to be taken down the right route practically? What type of question would you ask the social worker about their experience, for example? How would you do that?
I guess it is, if a social worker is coming out from a children and families assessment team is saying, my child has a disability, and I would like my child to be assessed by the Children's Disability team. How does that happen? And then there might be lots of reasons why that can't happen, but that's not the law. So I think it's the first step to say, well, actually, finding out, and there are so many resources online now where parents can check out the law. There's loads of lawyers giving advice online. There's websites. There's Luke has a lot. Don't you, Luke? You have a lot on the Ridian website and Cerebra and other organisations. So find out about those things.
So practically, would you be suggesting that they say we are specifically looking for services to include services under the Chronically Sick and Disabled Persons Act? Is that what you are suggesting?
Yes, I think that. And I think, I was going to say, you can go online and look at Section 2 of the Chronically Sick and Disabled Persons Act. And it says, and it's about assessed need. So when there is an assessed need, so that's the important bit of a child or young person, then the local authority must provide. And there are lots of services, and I did talk about some of them earlier, but it can be things like facilitating the taking of holidays. It can be short breaks, respite, those sorts of things that parents really struggle to get. And the other thing I think as well, and I'm saying this I'm going to say this very, very clearly, is a lot of parents are offered direct payments, so they become the employer of a personal assistant for their child or young person. It's a mammoth responsibility to take on, particularly when it goes wrong. It's paid at a very, very low rate, which works out sort of equivalent to the minimum wage often. And parents don't have to accept that. They can ask for a commissioned service, and they do not have to be forced into taking direct payments. And I say that really strongly because I've seen it when it goes wrong, and people have had to be sort of dismissed, and it's a minefield.
Very difficult. Very good point you make there, Cathie. I think that it's a trend that we've seen, and direct payments can be incredibly flexible, very helpful in some circumstances. But as you say, there does tend to be a bit of a trend that I've seen where it seems to be the only option that parents are informed about, and it doesn't necessarily work for all. And as you say, Cathie, it may be that for some, particularly those maybe even with larger packages, a commission service is going to be more consistent. I've seen that work as well. I think one of the practical tips that I've seen when I've had parents approach me, and this can be for education, but particularly for social care, is getting parents to kind of write down their day and their week with the child. Because I think this is the interesting thing. And, my sister's got severe learning difficulty. She's disabled. Growing up in that household, you kind of don't realise what's normal for you might not be what is considered normal or the norm for others. And it's funny how, that's the case, I think, for those who support children with disabilities, is that they do so much as part of their average day that to them it'd be a very typical day, doing this, getting up early, maybe taking 3 hours to get them dressed. If they have physical needs, they might require the use of equipment as well, and all these things. And of course, it's not until they start writing down everything that they do that it starts to dawn on them quite how much of their lives are taking up, looking after the child's needs. And of course, to some extent, that's natural. All parents do that. But it's only when you write it down, you say, well, hang on, no, I wouldn't be doing that but for the disability. I wouldn't be doing that but for the disability. And it starts to build a picture in their mind, starts to give them that dawn of realisation that actually we really could do with services here, and here, because it's taking up 8 hours of my week, or sometimes even 8 hours a day, just to do these things. And, particularly if there are other children in the house as well, as we talked about, it's about assessing the family as a unit. Because, if all your time is dedicated to helping your one child who is disabled, obviously you may need, your other children may be missing out in terms of their own activities, maybe whether that be after school clubs or social events or otherwise. And it's so important for both a disabled child and any other children in the household to get access to those services. So really writing down, and I would say have that in advance of the social worker's visit, so you can hand it over and say, well, I've written you our kind of typical week, and here's what's really causing us difficulty, where are the pinch points in that week. I think that's a good tip.
And I think, Professor Clements, you were mentioning another practical tip I would have thought is to encourage parents to look at the local offer to see how they can gain their entry into these kind of services. I mean, you mentioned that earlier, didn't you?
Yeah, I mean, having looked at an awful lot of local offers, and I'm sure you have, I'm not sure that's a source of much information. It seems to be designed to sort of condition you to lower your expectations. So local offices, I think, are generally seen as fairly disastrous.
What I mean, for clarity, to identify whether there is anything in the literature that the local authority has published that identifies there being a restriction to the route to the children with disabilities team. That's what I mean.
Yeah, I mean, lawyers will do that, I'm sure, if you're challenging that. I think that a family probably doesn't have much choice over who assesses them, to be honest. And I think a court would say, well, as long as the person is competent, they know what they're doing and they have appropriate skills, you can't choose to be assessed by Team A or Team B. But what is important is that whoever assesses you not only has the appropriate skills and understanding of actually what they're doing, but they have the ability to unlock the services that you need under the Chronic Sick and Disabled Persons Act. So if you can find any evidence that says this assessor can't do that, so often an assessor will say, well, I'm not allowed to give you anything other than early help or something like that, which is only time-limited support, then, I think what Cathie said, it's really important to write and say, look, I may have misunderstood what Mrs. Jones said, but she said that, this assessment could only provide me with 4 weeks early help or something. I'd be grateful if you could clarify if I misunderstood what was said, because I believe that is unlawful or something like that. So I think it's good to clarify if you start being told that you can't get this because I'm not allowed to give you this or you're not disabled enough, because the legislation doesn't say that. It says that all people who with these very low threshold, but a mental disorder of any description is one of them, have the potential to access this range of services if a professional thinks they need it. It's like going to a doctor and the doctor saying, well, I'm sorry, I can't, a GP saying, I'm sorry, I can only look at sort of, these things. I can't help you with anything else. Of course, they're the portal you go through. You may have to go to other experts, but they're the portal and they can't just say, well, we don't do this or that. And a social worker can't either. Very often these may not be social workers either.
Yeah, that's another issue.
Well, I mean, this is really enlightening, Chris.
Absolutely.
I'm sure that our viewers are going to be intrigued listening to this, and I do hope that parents and children out there, young people, adults out there listening to this will gain some insight into what is open to them if they use the system properly and if the local authority use the system properly. I'd like to thank our guests, both Professor Luke Clements and Cathie Long. Thank you so much for participating in this session today. Chris, any final words?
Yes, just to remind everyone that we will put the resources mentioned for template letters and guidance on the website. So, of course, you can all check those out. If you're in this situation and want to use those to advance your case, then please do so.
And find the resources that Professor Luke Clements has talked about and Cathie has mentioned. And including the standard letters that are on
absolutely, yeah. We will put those links on the website so that they can be followed and used, because it's the whole purpose of these magazines, isn't it, Mike? Is to tell people what their rights are and hopefully empower them to go out and exercise those rights and get the support that they need. So that's what those resources will be there for.
I suppose it reminds me of some years ago when I met with a lovely family of a 15-year-old child, and they told me that over the last 15 years, because of their child's disability, they have never been to the cinema, to a restaurant, And when I asked the question, why, they looked at me dumbfounded. How could you expect me to be able to do that? Because I am tending to the child's needs on a day-to-day basis, right into the evenings. And it is heartbreaking that so many people have to go through such an ordeal. And together with the fear that they have about turning to others for help because they feel that they're going to be criticised. I do hope that you have enjoyed today's session, and I do hope this has given you very valuable information to be empowered to turn to the social services and ask for help rather than to be too frightened to do so. And we are obviously here as a last resort, lawyers like ourselves, that should you need to require help. But thank you all for watching, and thanks again to our guests. Thanks to Professor Luke Clements, and thanks also to Cathie Long. And until next time, thank you.